provides consulting, fiduciary governance support, and also other type of investment advisory services, both to individuals and to retirement plans. He manages our retirement plan group. Chad's been in the industry for 20 plus years, services all the way up to some Fortune 500 companies in his history. One of the things that's unique about Dopkins is as part of our audits, there's matters that we run into throughout the course of the audit that are somewhat specialized. And one of the things we do is we integrate external sources outside of the audit team into the audit process where it makes sense. So for example, if a company, if it's a new plan that we're auditing, or if you have a change in your investment policy, we'll typically run that by Chad. What do you see in here? You seeing anything? It's not, wouldn't say it's a full-blown review, but it's nice to have somebody kick the tires, and it's nice to be able to sit down with plan management and say, this is what a professional saw. When there's specific court cases, legislation, guidance, things of that nature that come out that are impactful, sometimes we'll ask Chad to come out to our clients and talk to them about what's happening. Or if clients have questions about fiduciary matters, we'll bring Chad out to give them a little one-on-one education in that area. So that's kind of an overview here on Chad. And without further ado, I'll turn it over to him.
Thanks. Good morning, everyone.
Good morning.
I think that you're going to hear a lot of good things this morning, specifically on operational issues. As Andy said, cybersecurity is an ever-evolving topic as it relates to retirement plans. What I'm going to kind of lead off with this morning is just a basic overview of fiduciary responsibilities. It's a topic, it's a question that comes up quite often with either our audit clients, our plan sponsor clients in wealth management. There seems to always be some confusion regarding this issue, and I think a lot of that really revolves around the fact that for employee benefit plans, the government has done a really good job of kind of changing the rules almost on an ongoing basis. And so when you're looking at fiduciary responsibilities or identifying who is a fiduciary to their retirement plan and who is not a fiduciary, what is their responsibility, what is their role, it can be a little bit confusing. So that's really what I wanted to talk about to start things off this morning. As I said, the government really has done a good job of constantly evolving and changing the regulations and the rules that pertain to retirement plans. And what I have up here on the screen are some of the more recent legislative changes and regulatory changes that have had significant impact on plan sponsors and how they manage and how they run the retirement plans. Going back to the Pension Protection Act, which is now 10 years old, probably had some of the biggest changes and biggest impacts to retirement plans going back to when ERISA was originally enacted in the 70s. New updated 403B regulations. We're still dealing with frozen and terminated pension plans, and that's kind of, just evolving as well. We're now a few years into the new fee disclosure regulations that we're all dealing with, and have kind of changed the rules, not only in terms of the responsibilities on the service provider's end, but also on the plan sponsor's end as well. And as well as the new DOL fiduciary rule that was just finalized a few months ago and will be enacted in the course of the next 12 to 18 months, and is already being challenged both by Congress and by the financial industry. So these are a lot of things that organizations that sponsor retirement plans are dealing with, that are evolving and changing how they're managing their retirement programs. And what I wanted to do is really start with the first question that we're often asked from a lot of people is how is all of this impacting? What's the result? If I'm a plan sponsor, if I'm somebody who's a trustee on a retirement plan, how are these legislative and regulatory changes impacting how I manage my plan? Well, the bottom line is we're looking for what we're calling this win-win solution, where sponsors of the retirement plans, you have to pay more attention to the legal requirements of what your responsibility is, but you also have to look at the participant outcomes. You know, keep in mind that at the end of the day, what we're trying to do is provide our employees meaningful benefits at retirement to offset that salary or that loss of income when they go into that phase of their life. So it's a balancing act. And more it's a difficult balancing act that plan sponsors and organizations are facing when it comes to keeping up to date with all these things. So one of the questions that's always asked is, who exactly is a fiduciary? And I'm still surprised when I talk to, whether it's a business owner or a board or an executive director, really who is and who isn't within an organization a fiduciary to their retirement plan. And it's pretty straightforward. When you look at the rules, it comes down to really these three things. Do I exercise any discretionary control over the assets of my plan? Do I render investment advice for a fee? Or do I have any discretionary authority over the management of the plan? That's basically what it boils down to. Now the middle one we can kind of take out because that's more or less on the retirement provider side. But you have to look at this and say, it doesn't, you know, if your name isn't written in a plan document, it doesn't mean that you're off the hook. It's really, do I have exercise any discretionary authority over the management of the plan or the assets of the plan? If I do, I'm a fiduciary. And there is some confusion because a lot of people think that if I'm not the trustee on the plan, I don't have any legal responsibility. You know, I could be, you know, in human resources, and if I'm working on the plan or I'm in some way exercising some sort of control over how that plan is managed, I'm a functional fiduciary. Doesn't mean that because my name isn't listed in an adoption agreement or anywhere else that I have no legal responsibility. Through my actions, I have become a fiduciary to that plan, and therefore I have some legal responsibility. So you got to ask yourself some questions. Do I have any control over the investments in my retirement plan? Did I pick the investments? Can I change the investments? Can I remove a fund or add a new fund? If I can, then I'm a functional fiduciary. Those are the types of things that a lot of people really don't understand when they're trying to evaluate what's my legal role relative to the plan and do I have some liability here. If you are a fiduciary, basically, again, straightforward from the regulations, I have a responsibility to provide benefits to the participants and defray reasonable expenses. That's basically what the rules state. The key is that what I have here, you're subject to the prudent man rule, which means that I have to exercise my duty with the skill, prudence, and diligence on circumstances unprevailing that a prudent man acting in like capacity would do. This isn't a best effort scenario. Basically what the rule says is, hey, listen, if you don't know what you're doing, if you really don't have the skill set or don't have the capacity to do it, you have the responsibility to go and get assistance. And this is something that a lot of people don't realize. It's like, you know what, I'm running a business or we're running an organization here and we're not experts in this area, but we'll do the best we can do. That's not a real solid legal defense. So if you feel that, hey, listen, I don't have the capacity here, I don't have the skill set, I don't have the expertise, the knowledge, you have the responsibility to hire individuals, to hire organizations to help you to fill those gaps. Otherwise, you're opening yourself up to liability. And that is really what the risk is. If you know that you're a fiduciary and you understand what you have to do here, the question is, why should I really care? You know, what's at stake? And the DOL came out with a bulletin that basically said, you have to act solely in the interest of your participants and the beneficiaries. And you're subject to personal liability. This is the risk. And when you understand this, then it becomes very obvious that you have to take this role and these responsibilities very seriously. Because you're now subject to personal liability in terms of breaching or not fulfilling your duties to the plan. And that's really where the risk is. Now, I have a lot of people come up to me and say, okay, I understand that, Chad, but come on, what are we really talking about here? Yeah, all right, I'm personally liable, but maybe I run a small business and we're like family and nobody's going to come after, nobody's going to complain or whatever the case is. And, there's never a problem until there is one. There's never a disgruntled employee until there is. And what we're trying to do here is avoid this personal liability. And you need to understand that there are some fairly significant consequences to taking on this liability. Plan administration is one area. The Department of Labor, one of the key areas that they focus on, late payroll deposits. That's been a kind of a bugaboo of theirs for many years now. It's a prohibitive transaction. They can hit you with a 15% excise tax, make you go through a correction program. Late government filings is another one, 5,500 filing. The IRS has a penalty of $15,000 if you don't file it on time. The DOL steps it up even further. They have a $1,100 a day penalty with no cap. And I actually saw a DOL letter that was sent to a plan sponsor informing them that they had failed to file their 5,500 in a timely manner. And the issue could be resolved as long as they just simply wrote a check for $385,000 because it was over a year late. Now, I will tell you that the happy ending of that story is it got dismissed and was taken care of, and it was a small employer. But this is really what they're threatening you with when it comes to issues with plan administration. You may have seen lots of issues in the news, litigation, pending lawsuits, those types of things as it relates to service providers and fees. Bernie Madoff is still the classic example of understand who you're dealing with when you're hiring somebody to provide services to your retirement plan. Right now, there are over 70 lawsuits pending for excessive fees or hidden fees with regards to fiduciary breaches. I've listed some of the ones, the settlements here. Caterpillar, $16 million, Kraft, $9 million, Walmart, $13.5 million. Big names here, but what I will tell you is that this is really flowing downhill. There's already at least a half a dozen lawsuits on the books right now for plans and plan sponsors that have less than $10 million in their retirement plans. So it's not just an issue for Fortune 500 companies or those with deep pockets. There are now law firms that are specializing in ERISA litigation. And it really doesn't take much to unearth some issues with this. So lots of these companies, and what we're finding in the industry is it's cheaper to settle than it is to litigate. Even if you feel that you've done nothing wrong and you feel you've got a good defense, these lawsuits are taking years and years and years. And the legal fees, in many cases, trump what the plaintiffs are even asking for in terms of damages. So there are legal and lawsuit issues that are there as well. And then finally, you look at the government and the Department of Labor itself and their renewed interest and effort in cracking down on fiduciary breaches. These are some statistics from last year. The DOL closed over 2,400 civil investigations that resulted in almost $700 million of penalties and fines being assessed. That's in 1 year. And that's fairly consistent over the last 10 years, every single year. Not only that, but there were 275 criminal investigations that were closed and resulting in 67 criminal convictions. People are going to prison for these types of infractions. The government has correction programs. You may be aware of them. What they're trying to do here is get organizations to admit lapses in their responsibility and how they're managing and running their plans. Last year, over 22,000 applications were filed due to deficiencies. These are the good ones. These are the ones that are coming forth on their own and saying, yeah, we kind of screwed up, have mercy on us, but what do we need to do to make things right? And finally, at the bottom there, you'll see the EBSA, the DOL, several years ago instituted and launched a new program, a grassroots effort to kind of uncover problems in fiduciary breaches by having call centers and 800 lines set up where they're targeting the employees. And I've seen advertisements on TV regarding this, where they say, hey, do you think something's wrong with your retirement plan? Do you think that you've been wrong somehow, some way? Give us a call. Last year, over 200,000 inquiries were made through that program, and that's becoming the major way that the DOL is uncovering breaches in fiduciary duty, going straight to the employees and saying, hey, do you think something's wrong? Are you losing money and you don't know why? Somebody should be held accountable for this. Come and talk to us. So these are some of the potential consequences, whether it's regulatory, whether it's litigious, whether it's fines and penalties. If you have some skin in the game, if you are a fiduciary, there are some potential serious consequences to not fulfilling your obligations and your responsibilities there. So the question then is, how do I protect myself? If I am a trustee on a retirement plan, if I am a functional fiduciary, if I exercise some sort of level of discretion over the management of the assets in the plan, what can I do to insulate myself from this liability? It's all about process. Both the courts and the government have come back and said, listen, somehow, some way, develop a formal process for documenting all plan-related decisions, whether it's plan oversight, service providers, plan expenses, investment options. Have some process in place that is extremely well documented. It can't be up here. Most of the courts have come back and said, hey, listen, if you can't show us in writing how you're managing your plan or how you chose your service providers or how you're critiquing your investments, and if you're not following it and it isn't in writing, then we're assuming that you're not doing it. We're assuming that there's a breach. You're guilty and you got to prove yourself innocent otherwise. So the entire process must be documented. That's how you really are going to be able to insulate and ensure that you're fulfilling your duties and you're minimizing the liability. When it comes to plan oversight, identify who's legally responsible. Time and time again, I can't tell you how many times I've talked to trustees on retirement plans or boards overseeing retirement plans, and the common answer is, well, the broker is responsible for this, and the record keeper is responsible for that. And you go in and you look at and you examine the contracts and their service agreements, and at the end of the day, it all falls back to the plan sponsor. So do you have a pension or investment committee set up? Do you have some sort of governing body in place that on an ongoing basis is managing and documenting the decision-making process? Larger organizations, it would be reasonable to have some sort of pension committee or investment committee. Smaller organizations, maybe it's just a couple of people. Maybe it's a business owner or the CEO or the CFO or whatever the case may be, but you need to have something in place where there's direct oversight for the plan. I've seen that many times with organizations where you have the board and unless it's something that needs board approval, they're not paying attention to it, and they think that HR committee is paying attention to it, but they're not really looking at it unless an employee is asking questions or complaining about it, and maybe you've got an audit committee or an investment committee and they think they're doing it, and it turns out nobody really has their pulse on what's happening with the retirement plan. Our decisions, our plan reviews being documented. Many times you might have a service provider come in once a year, meet with them, kind of give you the dog and pony show, everything looks good, here's a review of the investments, and then they part ways and nothing is really documented. That meeting even took place, what was discussed, any decisions relative to that meeting, and there's no documentation of it. And again, the courts will come back and say, we're assuming you never met if you can't have it documented. Service providers, this is a huge area. 408B2, 404A5, the new fee disclosure rules that have been in place for a few years specifically target this area. How did you choose your service providers? Lots of organizations have been with the same service provider for 10, 15, 20 years, and there's nobody there that can even recall how we chose ABC record keeper or XYZ's platform. Nothing is documented. How did you choose? Are you benchmarking the services to other providers? Did you put the plan out for bid? Did you go through an RFP process? Have you benchmarked it? Compare the services to the needs of the plan. This is something that really is never overlooked. Your service provider can be charging you very high fees, but the list of the services that they are willing to provide is exhaustive, but yet your needs are maybe minimal, and there's not very good correlation between those two. And finally, are you benchmarking your cost to industry averages? 408B2, the fee disclosure rules, for the first time told plan sponsors you've got some skin in the game here. Have you made a determination? Those rules specifically say you need to make a determination as to the necessity of the services and the reasonableness of the fees. Most plan sponsors that I talk to have done nothing with regards to that. They get their annual notice, they look at it, they put it in the file, and they go on with life. And they haven't made that determination. And this is something that the Department of Labor is really going to be focusing their attention on. What documentation do you have that you fulfilled your responsibilities with regards to those regulations? When you look at plan expenses, this is probably the hallmark of a lot of the litigation that's pending right now. Plan sponsors that are asleep at the wheel, that don't even know what it's costing them in terms of overall plan expenses. So you need to evaluate all your external costs. What am I paying my TPA, my record keeper, my advisor, legal, audit, all of those types of things. Evaluate all your internal costs. What about my fund expense ratios? How do they measure up? Do I have any advisory fees or wrap fees built in to my fund costs? What am I paying in terms of commissions or any sales charges? Revenue sharing payments, huge, absolutely huge. It's been a focal point in the industry for a number of years. What am I paying my investment advisor directly versus what is he or she maybe collecting through the back door through the investments that they're recommending? Annuity fees is another one, redemption fees. Have you benchmarked the total internal costs and external costs of your plan and made a determination as to the reasonableness of that? And then compare the costs, as I said already, to the services that are being provided. Is there a good connection between those two? And then finally, when you're looking at investment options, you should have a document in place where you are identifying what was our selection process. How did we come to offer the investments to our employees that we're currently offering? What's our monitoring process? How are we monitoring the investments? How are we making a determination that they are prudent investments to be included in the menu? How frequently are we monitoring them? What criteria are we using? Performance-based versus fiduciary-based evaluations. I will tell you the former is really the method that most plan sponsors and organizations use. They say, well, if the performance is good, I guess we're okay. We don't have a problem. Keep in mind that the ends don't justify the means. This has actually come up in some court cases before, where lawsuits were filed and the defending plan sponsor came in and said, well, the performance is fine. There are no issues. And the courts have ruled, well, just because the performance is good doesn't mean you haven't breached your fiduciary duty if you never put a process in place to monitor, to evaluate whether or not those investments are prudent. So that's more of a fiduciary based, looking at it objectively and saying, okay, we are going to look at it on a quarterly basis. We've got a half a dozen different criteria we're going to use. and we're going to, look at, Morningstar benchmarks, or, whatever the case is. At least you have a process in place. It's documented, and you're following it, and that's really where the insulation from the liability is going to come from. So overall, in terms of protecting yourself, you've identified that you are a fiduciary, if you understand what your responsibility is and that there are some consequences to not fulfilling those responsibilities, the idea is create your own process. You can work with a fiduciary compliance consultant. We're seeing more and more organizations do this, at least just to provide assistance and assurance that, all right, I do have the processes in place, the documentation is in place, I'm fulfilling my role and my responsibility. You can try to outsource the liability where you can, whether it's through trustee, either directed or discretionary. This is an area that I see a lot of confusion on. There are many organizations out there that are more than happy to sign on as a trustee to the plan, and the business owner or the board or the committee is under the impression that they have just removed all the liability off of their shoulders and onto that trustee's shoulders. I will tell you the issue that we see generally with this is that most of those organizations are only going to act in a directed capacity. And all they're simply saying is, in our role as a directed trustee, we ensure that any instructions you give us will be executed the way you want them to be. They're not taking on any discretionary control. All of that liability still resides with the board, still resides with the business owner, still resides with the CEO. So there's a lot of confusion there. Very, very few organizations will sign on as a discretionary trustee. Okay. From an investment standpoint, you can try to outsource the liability by hiring an ERISA 338 investment manager. Somebody that basically says, I will take the investment decision-making process away from you, Mr. and Mrs. Trustee or plan sponsor, but whatever I want, whatever I say goes. You have no input, you have no control, you have no say in the investment menu that's being offered. Generally, one way that you can see it is to work with ERISA 321 registered investment advisors, or RIA firms. Our firm is an RIA that shares the liability. Basically says, we're signing on, we have some skin in the game with regards to the recommendations that we make, and we can be held legally liable for those recommendations. Finally, you see a lot of this, fiduciary warranties, especially with regards to insurance platforms. I guess a word of caution here. I've reviewed many of these, and in conjunction with a lot of ERISA attorneys, and the conclusion really is most of them are not worth the paper they're written on, because they're so narrowly defined and so narrowly written that the only time they're going to come into play is when the most obvious thing kind of slips through the crack and goes wrong, and 99.9% of the time that's never going to happen. But they're marketed as a means of outsourcing or insulating yourself in your liability. All of these things are only going to provide partial insulation at the end of the day, but there are some ways that you can kind of work with organizations that will help you ensure that you're doing what you should be doing. And finally, work with organizations that will help you incorporate a prudent process into the platform. And that's kind of going to give you your best alternative to making sure that you're doing what you should be doing. So just some final thoughts this morning. It's important for you to identify the legal roles and responsibilities both within your organization and with the service providers that you've hired. Understand who is and who is not serving and acting in a fiduciary capacity. Understand that consequences can be severe of breaching your fiduciary duty, both on a regulatory standpoint, a legal standpoint. There is some consequence to not fulfilling your role. Remember, it's always about process, documented process. That's the bottom line. If it's not documented, the assumption is that you're not meeting the requirements. Hire providers that will help insulate you. That's the best way that you can go about fulfilling your duties. Any questions at all about anything that I covered? Yeah.
Could you talk about the definition of a late payroll payment?
Late payroll payment is, that's changed over the last few years. They used to have, on the books, they've got a rule that says you have until, I believe it's the 15th in the month following the month in which the money was deducted. The reality now that the Department of Labor is looking at is how quickly can those funds be segregated from the employee's paycheck. And what they typically look at is how are you doing other deductions, let's say healthcare. You know, if within 48 or 72 hours you're able to take that healthcare premium deduction and get it out, the same should hold true for the 401k deduction in that case. So they're looking at it these days. You know, the standard is, you know, a matter of days that they're looking at it. And what they're also looking at is consistency over time. So if you have demonstrated that within 48 to 72 hours you've been able to do that in the past, and now all of a sudden we've got this one payroll that something happened and it took 5 days, that's going to be considered late, and they're going to want you to file that.
Yeah, and I'm glad that you asked that question. It's actually something that's a DOL we've seen. Also, Dopkins is in the alliance with RSM McGladrey, which is the 5th largest accounting firm, and so we get updates from them too as far as what they're seeing. They represent 2,000 clients across the country, and this is a topic that they are representing plans that with the DOL where they really have tightened their enforcement in this area. So we do have a couple of slides when we move on to the next section in this area as well. So it's a great question.
So, yeah.
The 403B and the 401k, is there any difference in the contribution regulations and when to contribute stuff?
In terms of timing, or?
Yeah, I guess in terms of timing. Yeah, 401k is very regulated, but there's the 403B.
Yeah, I mean, the updated 403B regulations that came in several years ago, the intent was to make them look and feel and run more like 401k plans. There's fewer and fewer differences, but operationally between the plans now than there ever has been. I'm not aware of, and Andy, you can chime in, I'm not aware of any specific rule that would be different in terms of how 403B contributions are handled versus 401k.
Yeah, so Brendan Brady, who's the senior manager at Dopkins in the back, is the closest to, I don't work on any 403B plan audits myself, so I'll continue to pass it over to him. But that's one of the things, you know, we have, within the four walls of retirement plans, there's a lot of complicated issues within the world of health and welfare, or you end up in defined benefit, or you end up in 401k, 403B, and then there's kind of this fiduciary responsibility that overlays the top. Brendan specializes in the 403B area.
So really with the 403Bs, as Chad mentioned, you know, functionally a 403B really now is running the same as a 401k. You know, same idea with contributions need to be remitted timely and so on. There's some kind of technical differences in the way that the plans are actually set up. You know, a 401k is a trust, a 403B is a collection of contracts, things like that. But as far as the day-to-day operation of the plan, really the idea of these new regulations a few years ago was they should run essentially the same. If I'm an employee of an organization that sponsors a 403B plan, I should not be legally entitled to a different, lesser set of benefits than if I work for a company that sponsors a 401k. So the idea is that if I'm an employee, really everything is pretty seamless. It all kind of looks the same. Kind of behind the scenes, there's a few differences. There's a couple nuances with eligibility, things like that. But as far as the contributions, same idea. Get them in as quickly as you can.
Is there timeline for maximum ending for the end?
So the letter of the law, the letter of the DOL regulation is as soon as possible or 15th business day of the following month. What they've shown in their enforcement actions, like Chad was saying, is as quickly as you can do it. What we're hearing from RSM is what they see a lot is 1 to 3 days. The DOL says if you can't do it within 1 to 3 days, they're late. A couple notes there as well. They've also held that, we've seen that some sponsors will send a paper check to the custodian with the contributions. They don't like that. They say if you can use an electronic funds transfer to, send your tax withholdings, to pay anything else, you should be able to do it for your 403B contributions. So it's really all kind of under the same umbrella. There is a safe harbor for small plans, which I believe is defined as less than 100 participants, and that is 7 days. But once you're over that safe harbor threshold, it becomes as soon as you can.
If your contribution, this is just an employee,
Right.
employer contribution only.
Okay.
So
I guess we should clarify that the employer contribution works differently. So the employee contribution, the idea is as soon as you take the money out of the employee's paycheck, it's an asset of the plan. And so if you hang on to it, it's a loan to the plan sponsor. An employer contribution is really going to be dictated by how your plan is written. The plan might say that we'll make a discretionary contribution at the end of the year. Then you can wait until the end of the year. It might say we're going to make a matching contribution on a payroll by payroll basis. And really in that case, your employer contributions should follow along with your employee contributions.
Yeah, my question was on we do an annual fiduciary meeting. Are you suggesting that we should do that more than once a year now, that we should maybe move that up so that we're looking at it more?
Yeah, it depends on what's covered in the meeting. There are certain things that best practices say can be reviewed on an annual basis. Looking at your provider costs or evaluating your provider, I think you're fine reviewing that on an annual basis. I think a strong argument can be made, though, that you may want to review or monitor the investments on a more frequent basis, especially in light of market volatility. Most of our clients, I will tell you from our perspective, when we work with our clients, we review the investments on a quarterly basis in terms of just from a fiduciary due diligence and a prudence perspective. So I think it depends, what you're looking at. Fulfilling your responsibilities with regards to fee disclosure, that may be every couple of years. So I think it just really depends on what aspect of the plan that you're talking about. So some should be more frequent, some can be much less frequent because there's really not going to change very much. But I think it would depend on if you're meeting once a year and just doing a comprehensive, all-inclusive, we're looking at everything. My only recommendation would be you may want to pull out that investment piece and do some sort, maybe not as thorough or formal a review, but maybe do something a little less formal, a little more frequently, just so there's no surprises. Question?
Just quickly, I know a lot of large employers are purchasing fiduciary and liability insurance. Are you finding that small employers are starting to pick it up, or are you not really seeing that so much?
They're starting to ask about it. Yeah, I think that as a result of what you're seeing in the papers and in the courts, we're getting asked that question more than probably we ever have been. Not to say that it's common. We talk to our clients about it. We talk about it a little bit. But I am seeing more organizations at least inquire about it. Not a lot are really, I think, signing up for it. And I think there's some confusion in terms of ERISA bonding versus that. I think when I talk to them, a lot of organizations think, well, we've got that. We've got this ERISA, fidelity bond, and that is what provides us. And so then it's just an education, conversation to say, that's doing a certain thing. But if you are the business owner, the trustee in the plan, and you're really trying to protect yourself, that's when you want to look at the the liability insurance.
Does that liability insurance protect the individual?
Yes,
Or does it protect the organization?
it protects the individual. And that's
So
that.
if it's a true breach, then the insurer can chase after the individual.
Yeah.
So it depends on how bad you get.
Yeah, but the intent is to say, all right, if I'm personally liable, if my personal assets are in jeopardy, can I buy some insurance that will, insulate me or protect me from that? So that's the intent. Where the fidelity bond, that's protecting the plan and insulating the plan. Yeah.
In regards to fees, you're paying the fees outside of the plan. So I want to use my lawyer, my investment advisor, and I'm not taking anything out of the plan to do so. Does it receive the same scrutiny?
No. Matter of fact, the Department of Labor come back and said, you want to pay unreasonable fees out of your own pocket? Have at it. We don't care. We think you're foolish, but you absolutely, it's not subject to the same scrutiny because at the end of the day, the participants aren't being impacted. And that's what the Department of Labor is really concerned about, is if the participants are footing that bill, then you have the responsibility to make sure that they're only paying reasonable fees. Anything out of pocket, neither the courts or the government is really going to have an issue with it. Any other questions?
I had one question on fees.
Yeah.
So you talked a lot about benchmarking fees, right, within the plan to document they're reasonable. Does it always you always have to go with the lowest cost when you're going through that analysis?
No, absolutely not. There's nothing in either ERISA or through the DOL interpretive bulletins that say that you have to go with the lowest cost service provider, that you have to use the cheapest investments. There's nothing on there. What the evaluation is a relationship between the services or the value that you're receiving and what you're paying for it. You could be paying well above average expenses either through your service providers or your funds, but if you're receiving Cadillac service and feel that there is good correlation there, it's not an unreasonable relationship. Just as I could be choosing the lowest cost service provider, but if I haven't seen the guy in 4 years, the DOL can come back and say that's unreasonable. There's a breach of fiduciary duty. Even though it's well below average, you're not receiving value for that, and therefore it's unreasonable. So it's always about that relationship between the value we're receiving and what we're paying for it. Yeah.
Is there any type of best practice in terms of how often you benchmark your plan?
It's a good question. We, for our clients, have the plans benchmarked every 18 to 24 months. Industry average is about that. You shouldn't see a lot of changes more frequent than that. Look at the plan and if the plan has changed, either in terms of the size of the plan or in terms of the head count, because those two factors have a huge direct impact on pricing. So if I've got a $5 million plan and I got 50 people in it and the plan has been $5 million and 50 people for 2 or 3 or 4 years, I wouldn't expect there to be a difference in terms of if I'm benchmarking the costs. If I had a $2 million plan that's now $5 million and it's been only a year and a half since I benchmarked it, I would absolutely want to benchmark it because the price structure on service providers is going to be vastly different for a $5 million plan compared to a $2 million plan. But absent any changes in terms of demographics, 18 to 24 months is more than reasonable. I'm going to leave you this morning with a quote from Ben Franklin that I think is very, very applicable to what we're talking about this morning. Although it's more commonly used in healthcare, whether it's cybersecurity, whether it's audit requirements or fiduciary responsibility, I think that that it's going to be extremely applicable. An ounce of prevention is worth a pound of cure. If you understand what your role is, if you understand the consequences, and you can put some emphasis on compliance, I think at the end of the day, you're going to be much better off than trying to alleviate headaches and fix problems later on. Thank you very much.